2005, you know? Actually 2010, but those cases are recent cases, all white juries, 31 of 159. And then 38, an additional 38, had only one person of color on the jury. And if anybody here has been to North Carolina, it's not just a few black people in North Carolina, you know what I mean? So it's not like there was nobody to be found to serve on the jury. So 40% of the defendants on North Carolina's death row right now are there because of all white juries or all white less one jurors. And that's, you know, important to note. Statewide, it was also found in the study that prosecutors struck qualified black jurors at more than twice the rate at which they struck white jurors in capital cases. Again, here and now, not 1980, not 1960, here and now, twice as likely. And this is qualified black jurors. This is not people that they often strike with criminal records or who live in a neighborhood where there are folks who know about the crime or something like that. It's actually, you know, the fine upstanding citizens that should be able to be serving on the jury are still getting stricken purely because of race. In addition, the study finds that in cases with at least one white victim, the defendant is, again, 2.6 times more likely to be sentenced to death than if the case does not involve a white victim. Last month, the first case under the RJ that's proceeding was coming to evidentiary hearing, and the district attorneys were flipping out because one of the things that is going to happen when these cases do finally come to hearing is that evidence is going to come forward. The legacy of discrimination around jury selection, around selection of who to prosecute capitally, etc., is going to be out there for the public. And it's not just the county information, this is statewide. This law allows for statewide information. And so the DAs are starting to complain that there's too much burden to produce the discovery around, you know, what their practices have been for the past 10 years or so. They wanted to delay the hearing, they aren't ready, they don't know about it, although, you know, this has been the law since 2009, and everybody who filed, who's on death row, had to file by August or September of 2010, so they had at least a year to know who was coming up. And then they attempted to remove the black judge who's sitting to hear that evidence in this first case. And interestingly enough, the second case that's to be heard is going to be heard by a white judge. The argument that was used to remove this black judge, or to attempt to remove this black judge, was that he had sat on prior capital cases in state. This white judge also had sat on prior capital cases in state. And the DA saw no, they just were bold. You know what I mean? Well, we want this guy off, and we don't have any question with this other guy. You know, luckily, or, you know, happily, or powerfully, we won that. And Judge Greg Weeks, who is the black judge on the Robinson case, is going to sit still on the Robinson case, and that evidence is going to come in January. Then, though, because they lost, the district attorneys and the folks who oppose the Racial Justice Act, which tend to be mostly the Republicans in the state at this point, did make a major push in the legislature on Monday, and were able to repeal the RJA on this past Monday, and a vote is 27-17 in the Senate. The House had already repealed it, and they did it in really tricky ways. Like, it wasn't the RJA that had come up. It was a medical, a marijuana bill, and then they switched around what the text was, and, you know, kind of quickly pushed folks in to take a vote. No hearings on it, no real, you know, debate about it, after it having been passed in 2009 overwhelmingly and supported by the governor. And so now we're facing a real repeal. The hope is that the governor who supported it in 2009 is the same governor is going to veto that repeal. But the danger in a veto is the power of an override, and the likelihood of an override. And so we have some information on the literature table back there somewhere. If y'all want to get involved in this, you can get information on it. You can call the governor, you can call legislators in North Carolina, call your family and friends who are in North Carolina, and get folks active on it, because this is a historic piece of legislation. Kentucky tried to pass something like it, and the Fed has also tried to pass something like it, but nobody really has. And we can't lose this, because this gives us potential in establishing once and for all that racism is running rampant in death cases, and we can establish that, and we can, you know, cripple the death penalty then, at least in North Carolina. And as we've seen in what just happened in Oregon 2 weeks ago, there was a pending execution in Oregon of an inmate who was volunteering. He's so mentally ill that he would prefer to be put to death than, you know, serve life in prison without parole and solitary confinement. And the governor was so troubled by that, and the governor is also a medical doctor in Oregon, and he recognized that, you know, there's some problems with this whole, you know, duty to do no harm and then, you know, flipping a switch and killing someone. that he put it back to his state and said, look, we're going to not execute under my watch now, and I want you all to figure out how to resolve this because we can't, this is not what civilized people do. So little by little, piece by piece, we can win this. And I'm happy to answer questions with anyone once we get to that point, and I apologize for taking so much time.
That's okay. Anthony Ricco.
Good afternoon, everyone. What I bring to this, I don't know.
Wait, we're gonna fix that mic.
I think that what I bring to this afternoon's conversation about the death penalty is from that of a lawyer who represents people in death penalty cases. I never met Lawrence Hayes, but a good friend of mine was in the car that night he got locked up. The perspective that I have when you see me, I'm a grown-up version of the little kids that you see running up and down 7th Avenue. And you sometimes wonder what's ever going to happen to them. So when y'all see me, you see what happened to one of them. I was born and raised on 116th Street and 8th Avenue. I went to Hughes High School. My wife went to Hughes High School. And I've been here. I've been a lawyer 30 years, and my whole professional career has been right here in Harlem. Living here. So the perspective that I bring is the perspective of one of your children who went to school and got an education and applied it to a very difficult situation. So I'm happy to answer the questions that you would have, that you would want to ask one of them kids that you see running up and down, what they think some 40 years later about what they've confronted. I can tell you that in my career, I've represented many young people facing the death penalty. Many of them have said to me, Mr. Ricco, I wish I had met somebody like you before. And it's heartbreaking to hear that. But I always remind them, well, you're meeting me now, and we have a job to do. I have found as a lawyer that there's nothing more dignified, nothing more rewarding than standing before a jury pleading for a man's life. I never intended to do death penalty work. If we hadn't stayed home and let George Pataki become governor, I would have never been a death penalty lawyer. Because George Pataki brought the death penalty in. And he transformed Anthony Ricco into a capital lawyer. Now there's Andre Cooper, Jarvis Brown, Jelani Solomon, and many, many others who are thankful to God that George Pataki was elected, because they may not have had Anthony Ricco as a lawyer or someone like him. So that's really my perspective. Mike alluded to something. He's a very graceful person, and he's sort of like, well, if he don't bring it up, I won't.
Bring it up, bring it up.
But now, you know, I'm gonna bring it up.
Bring it up.
Because y'all built your action network in my neighborhood, not vice versa. But I was one of the lawyers that represented Jessica Desnara in the Sean Bell case. And I know that that was very difficult for people to understand. I can tell you this, call it fate, or call it whatever you want to call it. I had breakfast this morning. And he's very, very desirous of coming here to explain to the community what he was doing, what he thought he was doing. And he is alone in that position, which will tell you something a little bit about who he is. He's not looking for somebody to pat him on his back, but he feels that he owes an explanation to his community as to what he was doing. And so maybe one day, you know, Michael will invite him. I'm sure he'll come. But back to the death penalty. You don't need statistics to know that in this country, the death penalty has been used to execute African American people. And I can tell you in my practical experience, You know, if you kill, the federal statistics, if you know, 10% of the victims are white women, they represent 78% of the death sentences. The death penalty is not driven by the race of the defendant. The death penalty is driven by the race of the victims. There are very few cases that are authorized when it's blacks on this side of the street killing blacks on that side of the street over crack. The death penalty comes into play when racial lines are crossed. And it's to put people in their place. And it's to let the system know that you don't have no relief from me. You know, who was shocked that the state of Georgia executed Troy Davis? I wasn't. I mean, it wouldn't have been Georgia if it hadn't. And each generation of us sort of wants to delude ourselves into thinking that we can put our arms down with respect to what we have to deal with in this world. You know, and so I don't really want to ramble on, but I can tell you that, you know, I've had a very, very, very powerful career. And the commitment and determination that you have to represent a person on death row is enormous. And, you know, I mean, Lawrence can speak to that. To have the death sentence imposed against you, that's a small minority of people who can say it, because people are generally executed. I'm good friends with a guy named Wilbert Ricco, who spent 44 years in Angola State Penitentiary to be released. And he's now doing death penalty work. I've represented people who have killed cops facing the death penalty, and I've represented cops who've killed people, though they rarely face the death penalty. So it's an interesting perspective. I was happy to come. I would come here anytime. Y'all should know that if the Philadelphia District Attorney's Office decides to reseat the death penalty against Mahmoud Abu-Jamal, I'm going to be serving as his counsel. And I'm looking forward to presenting his life in the courtroom. So I think really the forum is best served by answering questions. So I will end there, and then people can ask whatever they want.
All right, thank you. And for those, just so that you also know, as he just said, while he did represent Detective Exoneree in the Sean Bell case, he is currently assisting and working with Ed Wolford to help Larry Seabrooks, who many of you know and respect on some level.
Ed is actually helping me, but he likes the cameras.
I was trying to give him a little play. Telling you. Anyway, but they're both working on that case right now, which many people are indeed watching.
And you know, Mike, what's very interesting and what people don't know is that even in Larry Seabrook's case, we raised the Batson challenge. And Judge Patterson, to his credit, resat jurors where he found that they were being discriminated against. Now, we're not talking about drug dealer, murderer, bank robber. We're talking about a man with a 30-year career in politics where the U.S. Attorney's Office is striking an African-American nurse with a master's degree. And the judge ultimately finds there's no reason to strike. And I would love for people to see, to get that record and to see the arguments about it. So this, you know, setting up the jury to get a result is a part of not just the capital case, but all the cases. I'm sorry.
Right. And with regard to your other requests, of course, we will take that to the Bell family, which would have to speak on something like that. We're going to turn the table just a little bit and hear from Professor Robert Blecker, who, as I said in my introduction, is pro-death penalty.
Right.
Professor.
Listen up.
Thank you. Well, this is a tough audience to talk to.
Why? No.
That's a perfectly good question. Why? Because let's be clear about something. The public opinion polls show consistent support in the African American community for the death penalty ranges between 40 and 45%, which is a minority of the African American community, but it's a substantial minority. And though others here and though others in your community might try to shame you out of expressing your support for the death penalty, the fact is that it's almost split evenly. Now, I came prepared here because I respect the invitation enough, and I respect this group enough, to talk about Troy Davis. It took me hours and hours and hours to be able to talk about Troy Davis. Why? You heard a passing reference that 7 out of 9 witnesses recanted. That's the standard rap, right? And that somehow that all fell on deaf ears. Well, that couldn't be further from the truth, at least the second part of it, falling on deaf ears. In an extraordinary order, the United States Supreme Court, it was about the 4th time they got his case, the United States Supreme Court ordered a federal judge, Moore, to conduct a hearing at which Davis would be encouraged and allowed to present any and all evidence that he had, suggesting that he was innocent and that he had been wrongfully convicted. The hearing took place over several days. The net result was a 172-page opinion, marshaling and analyzing the evidence by the judge. I've carefully been through that 172-page opinion preparing for today's appearance. It's taken me tens of hours to go through it. Furthermore, I've spoken to 3 out of the 4 prosecutors involved in both the original prosecution and the appellate. I've also spoken to newspapers down there in Savannah, which I'll talk about in the course of it. The fact is that this 7 out of 9 witnesses simply recanting is simply false. It did not happen that way, and as the judge points out in meticulous detail, and I've come prepared today to talk about the evidence about Troy Davis. I don't know if my fellow panelists are, but if they're not, then I hope that they don't talk about the evidence of Troy Davis unless they're willing to go through it in meticulous detail. I obviously don't have that time. I am the lone person in support of the death penalty here, and there have been a number of comments about race in the death penalty, and I'm very sensitive to that, and I want to address that, but not in the first part of my comments, but later. And when I have a chance, I've been assured, in order to preserve some balance, to respond to some of what I've heard. You've heard about people's experience. Mine is not that relevant, but in a nutshell, I have spent thousands of hours over the last 30 years on death rows and in maximum security prisons in 7 states. I spent 11 years and 2,000 hours inside Lorton Central Prison, which was the nation's all-black prison system, the only all-black prison system. My life has been saved by inmates inside at times. Nobody needs to convince me that black prisoners inside are human beings. I know that, I've depended upon it, I have friends among that community. And as I said, people who have saved my life, like David Leon Brooks, who just died and where I was the principal speaker and gave the eulogy for him, who was convicted of murder. A murder, by the way, I'm convinced he never did. However, let's get to Troy Davis and let's get to September 21st, 2011. On September 21st, 2011, 2 people were executed. Let's not forget it. Troy Davis wasn't the only one. He was executed about 11 p.m. At 7 p.m., Lawrence Brewer was executed in Texas. And in case you've forgotten, let's remember why Lawrence Brewer was executed in Texas. Lawrence Brewer was a white supremacist, a racist, who, with 2 other friends, took James Byrd Jr., a perfectly innocent African-American guy walking down the road, having no beef with anyone, and they toyed with him, they put chains around him, they dragged him in the back of a pickup truck down an asphalt road, they watched his flesh get ripped from him piece by piece. The man suffered unspeakable misery, he was tortured by them, and eventually, mercifully, he died. Brewer went to his death with his racist tattoos on him, saying that if he had to do it again, he'd do it again. Lawrence Brewer deserved to die. Lawrence Brewer was executed. I am as certain that he deserved to die as I am that my hand has 5 fingers. Lawrence Brewer was a white man who killed a black man. Lawrence Brewer's death was an example of justice being done. Now, 4 hours later, Troy Anthony Davis was executed. And that one isn't so clear. I don't have time now, but I'm quite willing to, in discussion if you want to review the evidence. But here's what I can tell you. And I can look you in the eye and I can tell you this, after diligent research. The jury was right to be convinced beyond a reasonable doubt that he was guilty, given the evidence that was presented to them. Given the new evidence that was presented at the hearing before Judge Moore, Judge Moore was right to refuse to issue the writ of habeas corpus. Having reviewed the evidence now, in some detail and depth, I am convinced beyond a reasonable doubt that Troy Davis killed Officer McPhail. However, I would not have executed Troy Davis. Let me tell you why. It goes to two dimensions of the argument. One has to do with the burden of persuasion, and the other has to do with who deserves to die and why. The burden of persuasion at trial for guilt is, in the death penalty, as everywhere else in the criminal justice system, proof beyond a reasonable doubt. The jury must be convinced beyond a reasonable doubt that the defendant is guilty. If the jury finds the defendant guilty of a capital crime, we then move to the penalty phase. In the penalty phase, the jury makes a decision, life or death. Those are their only two choices. The burden of persuasion in the penalty phase is, unfortunately, and in my view, wrongly, again, proof beyond a reasonable doubt. There is an alternative burden of persuasion that the United States Supreme Court has held that the Constitution does not require. It's funny, it's coming out of Oregon, Oregon v. Guzik. This opinion, in my view, is wrong, as is, by the way, McCleskey wrong, in my opinion, which we can get into. Wrongly decided. I agree with you on that. The United States Supreme Court has held that all that's required is that the jury be convinced beyond a reasonable doubt that he should die. The other option is to talk about residual doubts, sometimes called residual doubts or lingering doubts. Let's talk about what those are. Those are doubts for which you cannot give a reason. Those are doubts which may not be reasonable, but they're real. They're real. Now, the United States Supreme Court has held that a person is not entitled under the Constitution to get a jury instruction on residual doubt. Troy Davis got no jury instruction on residual doubt. But his defense attorneys were allowed to argue residual doubt, and they did. I've reviewed that part of the trial transcript. In fact, it's the last thing they said to the jury. We accept your verdict. They have to. Defense attorneys have to accept the verdict. They have no choice. And so the strategy becomes awkward because now, having lost in the guilt phase, you're arguing for the life of your client in the penalty phase. And you don't want to anger the jury by saying, hey, you made the wrong decision in the guilt phase, so now you can make it up in the penalty phase. So you're in an awkward, defense attorneys are in an awkward position. I know. I co-teach my death penalty course with Kevin Doyle, who used to be the head of New York's Capital Defense. So what the lawyers did for Troy Davis in the penalty phase, their very closing statement to the jury, the last thing they said to them is, we accept your verdict. You're convinced beyond a reasonable doubt that he did it. But we ask you to look and ask yourself, do you have any lingering doubts? Do you have any nagging doubts? Do you have any residual doubts that he just might not have done it? And if you do, you don't want to be awakened in the middle of the night with those lingering doubts. Do the right thing. Give him life. The jury came back death. Now, in the hearing before Judge Moore, there are a number of ways in which the defense skewed things and failed to call witnesses that would have otherwise helped them for good reason because they couldn't subject them to cross-examination. There's a number of phony testimony. If we talk about who coerced testimony, we're going to be pointing fingers at parties that may not leave you all so comfortable. But the point still remains that the judge made it clear that his job was to act under a burden of persuasion that required Troy Davis to show clearly and convincingly that no reasonable juror could possibly have found guilt beyond a reasonable doubt. That is an unduly heavy burden to have put on Troy Davis. Even the burden that he asked for, which was just to show clearly, make it 60% likely that no reasonable juror would have been convinced beyond a reasonable doubt, was also too heavy a burden to put on Troy Davis. In my view, the correct burden to put on Troy Davis and the evidence itself is to ask, would most reasonable jurors, looking at all of the evidence, including all the new evidence that was raised, the so-called recantations, the new witnesses that came forward that said that Coles is the one who confessed, all hearsay, and they didn't call Coles, and they could have. But nevertheless, the correct burden of persuasion, in my view, is to ask the question of whether most jurors, reasonable jurors, considering all the evidence in the case, including all the new evidence, would have had a lingering doubt as to Troy Davis's guilt. I have a lingering doubt as to Troy Davis's guilt. I am convinced beyond a reasonable doubt that he did it, but I have a real doubt, a lingering doubt. And so my view is that because the death penalty is such a serious move and such a serious step, and should be reserved only for the worst of the worst of the worst, that a higher burden of persuasion should have been brought to bear. The judge was not at fault. He was constrained by the United States Supreme Court's burden of persuasion. The governor, however, was not constrained by that burden of persuasion, nor was the Board of Pardon and Parole. If I sat on it, I would have commuted the sentence for that and one other reason, and that is, my view is that the appropriate burden of persuasion is not only are you convinced beyond any lingering doubt that he did it, but also, are you convinced to a moral certainty that he deserves it? I'm convinced beyond a reasonable doubt that Troy Davis was involved in an earlier shooting that day for which he was convicted. I'm convinced beyond a reasonable doubt that he was involved in an altercation with a guy at the bus stop and when they were trying to take a beer from him. I'm convinced beyond a reasonable doubt that a police officer approached them, yelled to them to stop. Cole stopped. Troy Davis kept on running. The police officer had a nightstick. Troy Davis turned around, squeezed the trigger. The gun didn't shoot. The police officer reached for his gun, didn't get it unstrapped from his holster. Troy Davis shot him and then stood over him and shot him 2 more times. It's horrible. It's murder. But it's not Lawrence Brewer. It's not someone who raped and murdered children. It's not a serial killer. It's a horrible killing. It's a murder. It deserves to be punished with life in prison. My view is that the aggravating circumstance in that case, that it was a single killing of a police officer, does not warrant death. That the death penalty is a moral question and it is to be reserved only for the worst of the worst of the worst. And if Troy Davis was guilty of that, and I am convinced beyond a reasonable doubt, but still have lingering doubts about it, if Troy Davis was guilty of that murder as charged, by the way, remember, 7 out of the 12 jurors were African American, 7 out of 12. 2 of the police officers who supposedly coerced the testimony were African American. And in fact, one of them is an ordained minister and is known as a Boy Scout. This notion about racism, that this trial was infected by racism, it just doesn't hold up. Take the trouble, find the facts. But having said all of that, and having said that the judge was right, in terms of denial of habeas, given the burden of persuasion under which he was forced to operate, let me repeat again and close, and then I'll address racism later in the last comment. I'm convinced beyond a reasonable doubt that Troy Davis was guilty. I am not convinced to a moral certainty that he deserved to die for it, and I have a lingering doubt, a real doubt, that he just may not have been guilty.
Thanks.
Thank you, Professor Blecker. And I'm sure we'll get into it more once we get to the questions. We've got 2 more panelists. I'm going to go to Lawrence Hayes.
All right, Larry.
Thank you for having me here.
Right.
First I would like to say, one of the wisest abolitionists we ever known to the abolitionist movement, said, slavery has been fruitful in giving itself names.
Yeah.
It has been called a peculiar institution, the social system, and the impediment. It has been called by a great many names, and it will call itself by yet another name. I and you and I had better wait and see what new form this monster will assume, what new skin this snake will come forth next. And I will tell you